Welcome to episode 12. This is a discussion of Chapter 12 of UAE Crypto Litigation, available at www.uaecryptolitigation.com.
Right. And today we're looking at a really fascinating issue.
Yeah, so imagine you are the buyer in this scenario, right? You just spent a significant sum, millions of dirhams, on these industrial-grade cryptocurrency mining rigs.
Right. Highly specialized equipment.
Exactly. And your natural expectation is that these machines will be, plugged into some highly customized power grid, generating yield.
Right, because otherwise they're just expensive paperweights.
Yeah, exactly. But what happens if the company that sold you the machines has no place to plug them in and, no legal license to even try?
Well, that's the core of what we're diving into today.
Right. We are looking at the friction that happens when a multi-million dirham handshake made over instant messaging collides with the strict reality of written contract.
Yeah, it is a really profound challenge in modern commerce, particularly within the digital asset industry. We frequently see this commercial landscape where the core value of an arrangement, hosting and maintaining mining equipment, relies entirely on unwritten promises.
Right, because the industry just moves so fast.
Exactly. The formal paperwork might be drafted strictly as a simple sale of goods, but the actual commercial viability of the deal depends on this ongoing service. So the central question for the judiciary becomes, how does a court determine the true mutual obligations of the parties when the written document just doesn't reflect the operational reality?
Right, because in a traditional setting, the written document is it's typically viewed as the absolute perimeter of the deal, right? If it's not in the contract, it just doesn't exist.
Yeah, exactly. The four corners of the document.
But the digital asset industry, it operates so differently. Negotiations unfold over WhatsApp, Telegram, or even, in the comments section of an Instagram post.
They really do.
So our mission today is to objectively analyze how UAE courts and regulators approach these implied terms in crypto mining agreements.
Right. And to understand the judicial approach, we can turn to a highly illustrative 2023 judgment from the Dubai Court of Appeal.
Oh, perfect. Walk us through the facts on that one.
Sure. So the facts of the dispute center precisely on this tension between formal text and digital correspondence. A buyer purchased digital currency mining equipment for a significant sum, but following the purchase, the buyer asserted that there was this essential condition underlying the entire transaction. Basically, that the seller was obligated to provide a hosting location and, operational service for those machines.
Which, makes complete practical sense, right? If you buy a commercial jet, you don't park it in your driveway.
Right, yeah.
You need a hangar, maintenance crews, specialized infrastructure. And industrial mining rigs, they require massive power loads and industrial cooling systems.
Precisely. The hardware is basically useless without the infrastructure. But the seller failed to provide that hosting.
Oh, wow. So what was their defense when it went to court?
Well, when the dispute reached the court, the seller's primary defense relied entirely on the formal documentation. They pointed out that the executed contract was strictly for the sale of physical assets.
Just to build a sale, essentially.
Yeah, exactly. There was no hosting clause anywhere within the four corners of that sales contract.
And I imagine the seller also pointed to market volatility.
Yeah.
Because in this industry, the underlying asset prices fluctuate wildly, which, directly affects the value of the mining equipment itself.
They did, yeah. The digital currency market had experienced a substantial drop, which caused a massive reduction in the equipment's value. It fell to a mere fraction of the original purchase price.
Ouch.
So the seller's position was basically that the buyer was just experiencing buyer's remorse, right?
Right.
And was utilizing this unwritten hosting requirement as a convenient pretext to cancel an investment that had just turned unprofitable.
Which brings us to Article 246 of the Civil Transactions Law.
Yes, exactly.
Because, as I understand it, this is the legal lever that forces parties to act in good faith. Meaning, you can't simply hide behind a bare-bones sales receipt if custom evidence and just common sense indicate you were supposed to provide an ongoing service.
Right.
So how did the Dubai Court of Appeal apply that principle here? If I buy a car and the dealer promises over text to keep it in their secure garage but leaves it on the street, how does a court enforce a text message against a formal bill of sale?
Well, the Dubai Court of Appeal, which was acting as a court of second instance, meaning they have the authority to examine the facts anew, anchored its reasoning exactly there.
Right.
Article 246 mandates that contracts must be performed in a manner consistent with the requirements of good faith. But its most critical function here is establishing that the obligations of a contracting party aren't limited solely to the literal text of the agreement.
Wait, really? So it goes beyond the text?
Yes. The obligations also include what is appurtenant to the contract according to the law, custom, and, the very nature of the transaction.
So applying Article 246 means the court is explicitly authorized to look at the surrounding context.
Exactly.
It allows the judiciary to assess the entire evidentiary record, right, to determine the full common intention of the contracting parties rather than just being boxed in by the absence of a hosting clause in the main document.
That is exactly the mechanism. And to establish that common intention, the court relied heavily on a court-appointed expert's report, basically adopting it as the evidentiary foundation of its judgment.
And those experts are really crucial in the UAE civil system, right?
Very much so. They act as crucial fact-finders. And this particular expert conducted a really meticulous review of the digital communications exchanged between the parties. And the timeline of that evidence is highly revealing.
Oh, I bet. Where did it start?
The relationship initiated when the buyer responded to an advertisement on the seller's Instagram page, and this advertisement specifically offered the service of hosting and operating digital currency mining equipment.
Wait, so the court is actually treating an Instagram advertisement as the, preamble to a formal commercial contract?
Yes, exactly.
That's fascinating. So the marketing itself establishes the baseline expectation of an operational service, not just, hardware procurement.
Correct. And then the evidentiary trail moved to WhatsApp messages that were exchanged prior to the contract execution.
Okay.
In these messages, the buyer explicitly clarified that providing a hosting location was a foundational condition for purchasing the devices. And in response, the seller's employee confirmed via WhatsApp that they, possessed a facility for hosting.
If I'm representing the seller, my immediate defense is that those were just preliminary, non-binding discussions, right? They were ultimately superseded by the final written sales contract.
Right. And the seller presented a very similar argument. However, the court-appointed expert also documented communications that occurred after the contract was signed and the equipment was purchased.
Oh, after the fact. What did those say?
Well, this included a subsequent WhatsApp message where the seller's employee acknowledged receipt of the devices, but actually admitted there was currently no place to host them.
Wow.
Yeah. And the most decisive piece of evidence, though, was a formal email sent later by the seller.
Okay, what was in the email?
In this email, the seller explicitly admitted that they possessed neither the physical space nor the required regulatory license to host the devices, and they even issued an apology for the delay.
Well, that significantly undermines the seller's position. I mean, they admitted in writing that they lacked the regulatory license for the very service they advertised on Instagram and promised on WhatsApp.
Exactly. It clarified the reality of the transaction for the court. When synthesized with the principles of Article 246, the collective correspondence unequivocally indicated the contracting party's true intention.
So they couldn't just rely on the limited text of the formal contract.
No. The court concluded that the hosting obligation was an indispensable component of the agreement, directly rejecting the seller's defense.
Okay, but how did the court handle the seller's argument regarding the market crash and, buyer's remorse?
The court deconstructed that defense entirely. Given the overwhelming documentary evidence that hosting was a negotiated condition from day one, the argument that the buyer was using hosting merely as a pretext was found to be baseless.
Makes sense.
And the seller also attempted a secondary defense, pointing to a third-party electricity contract and claiming the buyer had failed to pay in advance on it. But the court noted that the buyer was not even a signatory to that third-party electricity contract, so it was completely irrelevant to the bilateral obligations between the buyer and the seller.
So the final resolution basically heavily favored the buyer's interpretation of the transaction, entirely based on the digital evidence.
Yes. The court ordered the rescission of the agreement, mandating the return of the significant purchase funds to the buyer, and additionally awarded damages.
Wow.
This judgment really demonstrates that in the UAE, essential obligations derive from the nature of a transaction, and the parties' demonstrated intent, even when communicated via WhatsApp or an email, are fully binding.
Right. And, zooming out a bit, it's fascinating how the court reconstructed the agreement from those digital communications. But if a federal body like the Securities and Commodities Authority, the SEA, or the central bank, the CBUAE, is looking at the macro picture, ensuring that a company's cybersecurity doesn't threaten the broader financial ecosystem, who is regulating the actual extension cords, server racks, and cooling systems on the ground.
Right, the physical infrastructure.
Yeah, because if the court views hosting as an ongoing operational duty, the regulatory framework must have a really specific perspective on how that duty is executed.
You are touching on the exact distinction between federal oversight and granular emirate-level regulation.
Yeah.
The regulatory landscape in the UAE is very mature.
Okay. For a licensed virtual asset service provider, or VASP, undertaking these activities, their duties go far beyond a simple sales contract. At the federal level, the SCA mandates that any licensed entity managing crypto assets adopt the best international standards regarding applied technology.
So that covers things like cybersecurity, data protection, and software oversight.
Exactly. And the central bank enforces similar strict principles for technological soundness, even though their primary focus is often on payment systems and stored value.
Right. The underlying mandate is for an effective technology risk management framework.
Exactly. Both federal bodies require licensees to maintain robust business continuity and disaster recovery plans, or BCDR plans. But when we look at the emirate level, specifically the regulations issued by Dubai's Virtual Assets Regulatory Authority, VARA, we see a much more granular set of rules.
But wait, if a company is just, plugging in machines, why are they treated with such high-level infrastructure standards? I mean, a BCDR plan for a standard web hosting company usually just involves backing up data to a redundant server.
Right. But a BCDR plan for a crypto mining operation involves managing immense concentrated power loads, industrial HVAC systems to prevent hardware meltdowns, and securing millions of dollars of physical hardware.
And that operational complexity is exactly why VARA's regulations are so rigorous. The VARA Technology and Information Rulebook 2025 mandates a strict risk assessment framework.
Meaning they have to plan for everything.
Exactly. A hosting provider must meticulously address operational risks like power supply redundancy, network connectivity, and hardware maintenance. Rule IH1 dictates that an adequate BCDR plan must be tested and updated annually, defining exact trigger events, recovery priorities, and communication arrangements.
So connecting this back to the Dubai Court of Appeal case we just discussed, failing to provide a hosting location at all is essentially a catastrophic failure of BCDR planning from day one.
It is a complete absence of the primary operational function. Furthermore, there is a critical regulatory layer regarding outsourcing. Under the VAA Company Rulebook 2025, if a client purchases mining equipment and outsources the operation to a VASP, that VASP is held strictly accountable to VARA as if they perform the function entirely in-house.
Meaning a VASP cannot just deflect regulatory responsibility by claiming, oh, a third-party data center lost power. They bear the ultimate accountability for the service delivery.
Precisely. To enforce this, the rulebook mandates a legally binding written agreement that specifies service levels, performance targets, and consequences for failure.
Oh, I see.
This regulatory requirement for contractual clarity is specifically designed to preempt the exact kind of ambiguity that led to the multi-million dirham dispute we just analyzed.
Now, there is another regulatory requirement mentioned in the text that fundamentally shifts how we view these hosting companies: the wind-down plan.
Yes, that's a vital, often overlooked component of the regulatory framework.
How does it work?
Under VARA, a VASP must maintain a wind-down plan that details procedures for the safekeeping and prompt onward transferring of clients' virtual assets in the event the business ceases operations.
Okay.
In a hardware hosting context, this encompasses the physical mining equipment itself.
Wow. So imagine moving tons of specialized multi-million dirham hardware out of a defunct facility while a company is collapsing. VARA essentially requires a step-by-step roadmap for that exact logistical nightmare before they even grant a license.
Yes, they do.
It really cements the fact that the VASP is a custodian, not just a hardware vendor.
That is the core takeaway. They are entrusted with a client's valuable income-generating physical property.
So, knowing how the courts utilize digital communications to establish intent and understanding the stringent regulatory requirements enforced by VARA and the SCA, the question becomes one of transactional architecture.
Right, the practical application.
Yeah, like how do sophisticated businesses actually structure these deals to mitigate risk and protect everyone involved?
The chapter provides very actionable guidance on this. The goal is to establish an unambiguous framework that completely insulates the core agreement from extraneous representations, like those preliminary WhatsApp chats or social media marketing.
Okay.
The industry standard is a bifurcated or modular contractual structure.
So you utilize a master services agreement, an MSA, to govern the overall legal relationship, and then deploy specific schedules or exhibits to detail the exact assets and the specific technical services being rendered.
Yes. This modular approach ensures the ongoing hosting obligations are explicitly defined with the same legal rigor as the initial purchase of the hardware. The contract must definitively state that the provider will receive, install, operate, and maintain the equipment on the customer's behalf.
But simply stating the obligation is insufficient, right? It must be quantified, because vague promises lead to litigation. So how do we mathematically define a hosting service?
Well, the critical metric is uptime versus downtime. This must be calculated with mathematical precision. For instance, calculating uptime as the total minutes in a month minus the minutes of downtime, expressed as a strict percentage.
Okay.
And crucially, the definition of downtime must explicitly exclude events beyond the provider's reasonable control, such as systemic regional network failures or hardware faults inherent to the machines themselves.
Wait, how do we track this uptime without just creating a new dispute over the tracking software itself? Like if the host says uptime was 99% and the client's dashboard says 95%, you are right back in court.
That is solved through pre-agreed API integrations or designated data oracles that both parties agree will act as the single source of truth for the machine's hash rate and connectivity.
Oh, smart.
And once that mathematically precise metric is established and trustlessly tracked, you link it to a self-executing remedy.
So instead of a client having to initiate a lengthy lawsuit for breach of contract because the machines were offline for a week, the contract dictates an automatic operational consequence.
Exactly. If the provider fails to maintain the agreed-upon uptime threshold, say, 98.5% in monthly performance fee is automatically reduced by a predetermined formula, the contract effectively enforces itself, maintaining operational alignment and completely avoiding the need for a lawsuit.
That makes a lot of sense. We also need to discuss protecting the physical asset itself. We touched on the logistical challenges of a wind-down plan, but how does the contract ensure the client retains unencumbered legal rights to their hardware?
The contractual architecture must explicitly affirm the buyer's absolute title to the equipment. It must contain a definitive clause stating that the equipment remains the sole property of the customer and does not become a fixture of the host's real estate.
Because in property law, if heavy industrial equipment is deemed a fixture attached to the building, a landlord could potentially claim ownership of it or seize it if the hosting company fails to pay their rent.
Exactly. That is a significant risk in commercial leasing. To prevent this, the agreement must legally classify the machines as chattels, not fixtures. Furthermore, the contract must include a negative covenant prohibiting the service provider from allowing any liens or encumbrances to attach to the equipment. Finally, it must grant the customer immediate, unconditional access to the hosting site to retrieve their machines upon termination or breach, mitigating the risk of the assets being held hostage during a dispute.
It all comes back to establishing an absolute perimeter around the agreement, which brings us to the final and perhaps most crucial contractual mechanism.
Right.
Wait, so after all we discussed about the court using WhatsApps and Instagram ads to find the truth, you're saying a good contract should actually wipe all that out.
Right.
How does a transactional architect prevent a court from looking at those messages?
By deploying a robust entire agreement clause.
Oh, so it functions like a legal firewall, essentially incinerating all prior communications.
That is a very accurate way to visualize it. An entire agreement clause explicitly states that the written contract, along with its designated exhibits, constitutes the full and exclusive understanding between the parties. It legally invalidates and cancels any prior written or oral agreements, representations, marketing materials, or negotiations relating to the subject matter.
It forces all binding obligations strictly into the four corners of the formal document. By implementing this clause, you intentionally leave absolutely no room for the judicial implication of unwritten terms.
Correct. When you integrate the bifurcated modular structure, the mathematically quantifiable metrics, the self-executing remedies, strict property rights protections, and a dispositive entire agreement clause, you replace the informality of instant messaging with a resilient, predictable commercial architecture.
So to briefly summarize our analysis for you, the listener, Unwritten terms in digital communications can absolutely be recognized as legally binding by UAE courts based on foundational principles of good faith in the surrounding evidentiary context.
Yes.
However, mature regulatory frameworks like VAR and the SCA and sophisticated contractual architecture like master service agreements and entire agreement clauses are the professional standard to ensure operational resilience and avoid these protracted disputes.
Exactly. And having established the foundational principles by which the UAE courts characterize crypto assets and the diverse commercial relationships they engender, the analysis now turns to the very creation and legal substance of the agreements that govern them.
Right.
The crypto asset market, particularly in its peer-to-peer and over-the-counter manifestations, is frequently marked by a degree of informality that would be unacceptable in traditional finance. Agreements of significant value are often concluded not through drafted contracts, but through the ephemeral medium of instant messaging applications and oral undertakings.
A whole different world.
It is. And this commercial reality presents a profound challenge to the judiciary, which is tasked with discerning the existence, terms, and enforceability of these unwritten bargains. So the next episode, which covers part 2 of the book, will examine the specific legal tests applied by the UAE courts to the formation and nature of these unwritten crypto asset agreements.
That brings us to the end of our discussion on Chapter 12. This chapter's structure is the standard methodology used throughout the book.
Authored by Mahmoud Abuwassel, and drawing on analysis from over 100 judgments, UAE Crypto Litigation serves as an indispensable resource for those in the digital asset industry.
To read the full analysis for this chapter and to explore the complete 7-part life cycle of a commercial dispute covered in the book, please visit www.uaecryptolitigation.com.
The discussion in this podcast is for educational and informational purposes only and does not constitute professional advice or any other professional relationship. Please consult with a qualified professional for advice tailored to your specific situation.